Welcome back. Accused Idaho killer Bryan Kohberger was in an Idaho courtroom today.
We are going to ask the court to set preliminary hearing out into June. We would request the 3rd or 4th week of June and probably 4 or 5 days for preliminary hearing. Mr. Coburger understands his right to a timely preliminary hearing, and he's willing to waive the timeliness to allow us time to obtain discovery in this case and be prepared.
And Mr. Thompson, are you in agreement with that?
The state has no objection to that, Your Honor.
The hearing, it simply means that you would not be able to come back and challenge that the state did not present probable cause within 14 days. Do you understand?
Yes.
Have you had enough time to speak with Ms. Taylor about your decision to waive your right to a speedy preliminary hearing?
Yes.
Do you need any additional time to do so?
No.
Then I will ask at this time, as to the 5 counts, felony counts that were charged in the criminal complaint that was filed on December 29th of 2022, are you waiving your right to a speedy preliminary hearing and agreeing that that hearing can be held outside the 14-day period?
Yes.
And Ms. Taylor, do you concur with his waiver?
I do, Your Honor. Thank you. No, Your Honor. Thank you.
Okay. Mr. Coburger, then you will be remanded into custody on your same no bail at this point in time, pending further proceedings. Again, we'll send notice out to counsel, and we will be in recess for this morning.
Thank you, Your Honor.
Thank you.
Prosecutors and the judge agreed to have that preliminary hearing on June 26th. They say to let the defense team go over the evidence. It's a lot of time, 6 months. Held without bail. Why would the defense want this sort of delay? Do they think they have no shot at any success in a preliminary hearing now? Is it because the evidence, including the cell phone records, the car tracking with the phone and being on surveillance video near the home where the murders happened, DNA on the knife sheath left at the crime scene is so overwhelming? His Pennsylvania attorney doesn't think it's that overwhelming.
I thought it was a strong circumstantial case that had holes and that could be exposed by a competent, good defense attorney like Attorney Taylor, I felt.
What would you say the biggest holes are?
I have been talking about like the biggest evidence and going step by step, because they are going to, defense is going to attack each part of the evidence separately, really, because the Commonwealth's case is really based upon circumstantial evidence. There's no direct evidence against Bryan. So their case is in the whole, whereas defense will be attacking each piece of evidence individually, I believe.
Joining us now, prominent criminal defense attorney Mark Eiglarsh. Mark, great to see you. So what do you make of this decision to move the preliminary hearing back to the end of June? Is it a strategic advantage for the defense?
My friend, if they could have moved it from June of this year to June of 2025, they could have and should have done that. There's no benefit in going anytime soon. If somehow he truly was framed like the Mona Lisa and he answered some of the defense's questions reasonably, like, yeah, I know how my DNA got on the sheath, and yeah, I can explain why my car was there, then they would say, my goodness, we have an innocent client on our hands. We need to rush this to a preliminary hearing. They're waiting because, candidly, they don't have it. There's no benefit that would come from it.
Do you expect that the roommate who apparently saw the suspect will be testifying at the preliminary hearing?
Yes. If they can avoid it through an affidavit, great. But no, she's a compelling witness. It's another piece of the puzzle. Someone having bushy eyebrows, in and of itself, not that big of a piece of evidence. But in conjunction with all the other pieces of evidence, it forms one picture, and it points to him.
Why do you think 4 to 5 days? I mean, that's a pretty long for a prelim, no?
Well, there's a lot of evidence. The scientific evidence alone, you've got to really prove why it is that they believe it's him. That alone could take half a day.
And what about motive? And so far, nothing presented. In the 6-month period, prosecutors could get a lot more evidence, where we're talking about the defense getting an advantage. By the time the preliminary hearing happens, the prosecution may even have a stronger case.
Okay, that's possible. But generally, cases for the defense get better with age like wine. Prosecutions, they want to go as quickly as possible. Secondly, they don't have to prove motive. And I'm making a prediction right here on your show. Unfortunately, I don't think that we ever get motive.
Thank you for watching. Go to newsnationnow.com to find News Nation on your cable provider. And don't forget to click the red subscribe button below to get more of News Nation's fact-driven, unbiased coverage.